We're back on the record.
We are back on the record on Beth Cat, and it's Mr. Chair's time.
Good morning, Mr. Chairman, members of the Taxi Cab Authority. For the record, I'm Scott Scherer of Rousing Hyatt Farber Schreck, appearing today on behalf of the opposing interveners, Taxi Management and Curb Mobility. That was a lot to respond to. I thought we were covered most of this in the opening and closing briefs, but let's start with the basics. The applicant and the interveners supporting the applicant or the applicant's position have the burden of proving that the proposed pass-through charge is justified, reasonable, and in the public interest. It's their burden. We heard a lot of testimony from Mr. Yorio about the patent process and what would happen in case of the patent process. Testimony, by the way, Ms. Premseritz tells us that attorney argument is not evidence. None of that was in the record. It's not evidence. We heard a lot of testimony from Mr. Tomlinson with regard to the history of these patents. And there's very limited evidence with regard to the history of these patents and the evidence. So let's go to what the facts really are and what the facts are that are in evidence. First of all, the proposed license agreement has not been executed. It's not even been finally agreed to by anyone. It's proposed. That license agreement defines licensed patents. This is Exhibit 14, I believe. Defines licensed patents as any issued or future patent and or any pending or future patent application that licensor owns or controls. So when we talk about the potential term of the agreement, because the term of the agreement, you go down to Section 5, which is the term, I believe it's Section 5. If you go down to the term provision of the agreement, the term of the agreement is, yes, Section 5. Shall commence upon its effective date, shall continue until the expiration date of the last valid claim of the issued licensed patents to expire. So if any other patents are issued in the meantime, they extend the date of the term of this agreement. And assuming this is the agreement that's ultimately signed, we still don't know that. The other facts we have is Mr. Balaban, the applicant, or the applicant's representative, testified that they've incurred no costs to date with regard to as a result of these patents. The only costs they've incurred are the costs of this proceeding. That was in his deposition that he testified to that. They brought this proceeding voluntarily. I would suggest those are not costs that are appropriately in the rate base. We heard
They are not
appropriately in the rate base. Mr. Tomlinson says that the writing public hasn't been paying for this technology. I would submit that they have. Because what is properly in the rate base is what each and every operator has paid to their licensed or to their technology providers to provide that technology. It's technology that currently exists and has existed for years. What we've heard also in the testimony from Mr. Balaban is that he's been using the predecessor of Captain's technology since 2005. Mr. Bordenaro, Captain's Vice President of Technology, I apologize if I got his title wrong, testified that the Captain Fleet Manager system was in existence when he joined the company in 2008. The first of these patents was filed in 2011. Mr. Yorio says we're looking at 2031, 2032. That may be for that patent. Because if I'm reading the evidence correctly, if you look at the patents themselves, several of them were filed in 2018, 2019, 2021. If they go from 20 years from that filed date, we're looking at potentially up to 2041. I don't know where he's coming up with that number because it's not in evidence. What is in evidence is the patent, the abstracts of the patents that actually have the dates they were filed on. Instead, they rely primarily on conclusory testimony of biased witnesses who claimed attorney-client privilege whenever they were pressed for details. Conclusory self-serving statements are not sufficient to meet their burden. They rely primarily on the testimony of J.J. Bell, Andrew Myers, and Noah Massell. Mr. Bell took it upon himself to negotiate, or with Mr. Myers' direction and approval, based on the testimony, to negotiate on behalf of the industry. We didn't have the industry asking him to do that for them, and allegedly negotiated the proposed license agreements at, quote, arm's length, close quote, with IVSC's owner, Mark James. Yet Mr. Bell is clearly biased. And I don't mean biased in a derogatory manner, but he has other interests that were not consistent with the interests of the industry or the interests of the public. First, he has an interest in Captain. He serves on Captain's board of directors. His family owns an interest, actually owns shares of Captain. This agreement clearly benefits Captain in at least two ways. First, it relieves them of their indemnity obligations to pay attorney's fees for any of its customers against whom IVSC may attempt to assert their patent claims. And second, Captain will receive 25% of the pass-through charges collected by any of its customers to help with its research and development budget. What else is in the record? Well, Mr. Bordenaro testified, yeah, I have employees, I have expenses. Sometimes those expenses go up. I would suggest that is not the purpose of a rate case, to compensate technology providers for their research and development expenses. Second, Mr. Myers, one of the other witnesses they rely upon, also shares the same bias. As his testimony made clear, Mr. Myers sees this as an opportunity to obtain a windfall to his company to help fund their budget. The applicant themselves, the Balaban, or at least Mr. Balaban and his family, also own an interest in Captain. They also have an interest that is not necessarily consistent with that of the rest of the industry. But the interest in Captain is not Mr. Bell's only bias. As he testified, until January, his family owned one of the operators who would be subject to IVSC's patent claims. And in the unlikely event that they were found to be valid, his family would be subject to payment of back royalties. With regard to the payment of back royalties, Mr. Bell stated in his testimony that he was, quote, or that he, quote, was trying to avoid that at all costs, close quote. The result was a higher pass-through charge because Mr. Bell, quote, would much rather have it moving forward than have to have a big upfront payment to cure the back, close quote. This is not arm's length negotiation. He's out of the Clark County business now. Protecting his family's interest, I get it. I'm not saying that's inappropriate for him to want to do, but protecting his family's interest, not necessarily the interests of the industry. Make sure that there were no back payments for prior royalties, and instead was a larger upfront payment that the public will have to pay going forward. This is a negotiation between the owner of IVSC looking for a way to monetize patents that would probably be ruled invalid if they were actually litigated, and a party who no longer cares about Clark County tax cap rates and is looking for a way to save the technology company he's invested in and prevent any risk to his family as a result from their prior use of that technology. I would suggest that this negotiation was more about how much they thought they could sell to the industry and to you, members of the Taxi Cab Authority, than it was about what was in the best interest of the industry and the writing public. Throughout his testimony, it is clear that Mr. Bell relied heavily on what he was told by IVSC, clearly an interested party, and did little independent research. The only independent research he ever referred to was, well, he consulted with his patent attorney. Well, what did they tell you? Attorney-client privilege. Can't tell you that. Over and over and over again. They claimed attorney-client privilege and would not give us the details of what really went into this proposed rate. Simply reading the website on which IVSC relied, as Mr. Messel testified, shows that the standards set forth on that website were misapplied in this case. In particular, they applied percentages from other, that you heard this 3 to 12% number. They applied percentages, those are from automotive, computers, unregulated or much less regulated, high growth industries instead of a highly regulated low growth industry. And if you read that website, and it's part of the evidence, it's in the record. If you read that testimony or that website, it suggests that the rates are higher in high growth industries and lower in low growth industries. And that is what we have here. Additionally, they applied those percentages to the revenue base of the operators. Their attempt to claim that the income of the technology, rather than the income of the technology companies. That website, if you look at it, that Mr. Messels relied upon, also states that you look at the revenue of the licensed product. Look at the net sales or profits from the licensed product. They want to tell you that the taxi ride is the licensed product, not the technology. As Mr. George testified, also in the record, the amount that would be raised by this pass-through charge is significantly more than he pays for technology for his entire fleet across the country, which is larger than the entire Clark County market. They are suggesting not that they get 3 to 12%, they're suggesting they get 100%, more than 100% of the revenue from the licensed product. That simply is not appropriate, and even if these patents were valid, would not be accepted. It has been said many times by both the chair and the vice chair and by the parties that this is not a patent proceeding. While we have made references to certain general patent law issues, such as obviousness and the lack of novelty, that is simply to make clear that there is substantial doubt about the validity of the patents. We do not expect the authority to determine whether the patents are actually valid. But I would suggest to you that until there is a proceeding, or at least an actual signed binding settlement agreement, that the applicant and the interveners supporting the applicant's position are asking you to engage in rank speculation as to what the actual costs will be. Because we don't know, and they don't know. They argue that that the taxi industry will be devastated by this, that they'll have to stop using this technology. As Mr. George testified, there are alternative technologies available. As Mr. Dewan testified, Curb is prepared to step into this market, and contrary to what you heard earlier today, Mr. Dewan specifically testified that he, with his technical background, did review the patents, that he did hire patent counsel to review the patents, and that he does not believe, and they did not believe, that Curb's technology violates any of the patents. Now, they couldn't do a check against Captain's technology. They don't have access to that. And every time we were asked, what about Captain's technology violates patents, we were met with the same attorney-client privilege argument. Now, they're entitled to claim attorney-client privilege. But they can, if they're going to insist upon invoking the privilege, they cannot meet their burden of proof in this case. So again, this is not a patent case. But Captain, in his brief, and Mr. Yorio this morning, argues that, well, they did not meet the rules of procedure in the district court for contesting the validity of a patent. Not a patent case. We weren't required to in the first place. Secondly, those very rules he cites are rules they did not comply with in trying to claim that the patents are valid in the first place. He says they provided a claim chart, but they provided a claim chart against the statute, 706.1516, a statute that by its terms does not apply. In this case, it applies to the Nevada Transportation Authority, and it applies to technology to be acquired by the Nevada Transportation Authority, not transportation used by the operators. As Captain admits in their closing brief, the claim chart, if you can call it that, which IVSC provided, is against the statute and not against the, quote, accused instrumentality, close quote, which is what the rule he invokes requires. So again, I would go back to the chairman's question. Is what's good for the goose good for the gander? They want to hold us to those rules, but they don't want to comply with them themselves. Because they did not, at no time did they ever provide a claim chart that is addressed to the accused instrumentality, i.e. Captain's technology. That claim chart also applied the 852 patent to the statute. Andrew Myers of Captain in his testimony said that it was, quote, business as usual, close quote, when IVSC's claims were based on the 852 patent. Yet no one has provided a claim chart for any of the other patents against the accused instrumentality. There is zero evidence with regard to what how the other patents might possibly apply in this case. With regard to the license agreement itself, Mr. Yorio testifies, because it's not the record, that indemnification is never in these agreements. Yet if IVSC is so certain that its patents are valid and not subject to the prior art, much of which is in the record, or at least references to it from the applicants and Captain's own witnesses is in the record. If they're so certain it doesn't violate the prior art, why are they unwilling to provide indemnification? The other thing that is in the record is that they haven't filed a single lawsuit. They haven't notified any of the operators. They haven't formally made any claims against any of the operators, even in a letter. The only letters that were sent to Captain. Captain notified the operators, but IVSC has not made any claims against the operators to date. Going back to NRS 706-1516, and I apologize if I'm jumping around a little bit, trying to respond to some of the claims that were made earlier. The owner of IVSC, in official testimony in front of the Nevada legislature, stated that the capabilities required by the statute, quote, could be accomplished by companies using current systems, close quote. He went on to say that, quote, there were 11 different companies could have brought a product forward in San Francisco, and there were a number of different companies that would respond to the RFP in Nevada, close quote. This is an admission by the owner of IVSC that the technology required by the statute would be acquired through an RFP, i.e. by the Transportation Authority, and that their technology was not and is not novel. In addition to Mr. Bell, Mr. Messel is clearly biased. Not only does he work for IVSC, who stands to reap a huge windfall from this proposed pass-through charge, but he personally stands to receive a percentage of that windfall as compensation for his efforts. Mr. Messel is not an expert, and he wasn't qualified as an expert. You heard from the other parties today, well, there was no expert testimony showing that these patents were invalid. There was no expert testimony showing they were valid. There was an opportunity in the scheduling order provided by the hearing officer for all parties to identify experts, and then if necessary, to identify rebuttal experts. Well, the applicant and the interveners supporting the applicant's position never identified any experts. Granted, we did not identify any rebuttal experts. Again, it's their burden of proof. If they had presented expert witness, expert testimony, we would have gone out and gotten our own experts to rebut that. Faced with these incontrovertible facts, the applicant and supporting interveners resort to misrepresenting the testimony. They claim that no one analyzed the patent claims, but as discussed earlier, Vishal Dewan clearly testified that he analyzed them both personally and with patent counsel and determined that Curb was not infringing any of IDSC's patents. Mr. George testified that multiple other technology providers were aware of the patent claims, represented that they were not an issue with regard to their technology, and offered to indemnify his companies against any claims of infringement. In fact, AutoCurb, he testified, did indemnify him, did agree to indemnify him against claims of infringement. So there are alternatives available in the industry for this type of technology. What also was testified to, Mr. Balin testified that even without the technology, they could continue to operate, and they could continue to operate in compliance. It would be more work for them. It would be less efficient, but they could continue to operate. So the catastrophic consequences that you're hearing about today of this speculative potential patent litigation simply aren't supported by the record. Taxi Management and Mr. George's company, two of the largest operators in this market. They don't believe that this pass-through charge is justified. They believe it would put them at a further competitive disadvantage with regard to other forms of transportation, including the transportation network companies and others that are coming along, whether it's the Boring Company, whether it's other forms of transportation. You've heard a lot today about NRS 706.1511C. I would suggest that the last phrase of that section says that it is your job to maintain sound economic conditions in the transportation industry. And continuing to raise charges on the riding public is going to ultimately drive them to either other forms of transportation or, worse yet, drive them away from Las Vegas. There's been a lot of press lately about the value that Las Vegas offers, or the lack of value that Las Vegas offers, about other fees. Mr. Tomlinson said, there are resort fees, there are all sorts of other fees being imposed on the tourist that comes to Las Vegas. And now they're proposing that we tack on one more. Yes, it's only 50 cents. But it's one more indication to that tourist that they are being nickeled and dimed to death when they visit Las Vegas. And I would suggest to you that that is not in the public interest. There was a question about whether this tariff would apply in Northern Nevada, or whether this charge would apply in Northern Nevada. Clearly, the answer is there would have to be, the Nevada Transportation Authority would have to be. But if you look at the license agreement, there is nothing that limits it to Clark County. So essentially, if that license agreement were signed, they would get a license to use this technology. Anyway, there's no territory, as I can see, designated in the agreement. Which means that Clark County passengers are paying for the use of that technology in other markets. How is that fair to the riding public?
On that point, Mr. Chair, you agree, it's your position that couldn't apply anyway because it would have to go to the NTA for approval, at least no objection to a tariff change.
I would agree. If I were on the NTA, however, I would object to tariff change
But-
because it's already been paid for.
I get that.
If this license agreement signed, it's already been paid for by Clark County. And we get to freeload on what
Right.
Clark County's already paying. Let me just go through and see if I've got anything else I need to address. And I think this has been addressed, but again, with regard to Mr. George's testimony, those NDAs protect Captain's competitors. Mr. Yorio wants the privileged information, proprietary information of Captain's competitors. I would suggest to you that that simply wasn't Mr. George's to give. They could have asked for subpoenas. They could have tried to go get information from those competitors themselves, and they could have litigated that issue if they felt it was that important to this particular case. And again, it is, say it again, their burden, not our burden, their burden. Mr. Yorio says there were 111 different claims. But again, the only information we've gotten to show in any way those claims might possibly be relevant is through a claim chart that addresses a statute that by its terms doesn't technically apply. They didn't provide a claim chart against Captain's technology. When asked to provide any further information, they refused, claiming attorney-client privilege. Mr. Tomlinson said that we probably could have gotten the information we wanted. IBSC was ordered to provide responses to our interrogatories and our requests for production of documents and did not provide them, refused to provide them unless we entered into an extraordinarily onerous protective order. That would have been limited to attorney's eyes only, which meant I couldn't have had technical experts review those documents. And even that was at the very last minute that we finally got that offer to enter into a protective order, and only after they've been ordered after a motion to compel to provide those documents. So to suggest now that there's somehow that we were deficient in not getting or providing those documents is the height of hypocrisy. With regard to the suggestion that there could be an opt-out, first of all, again, there needs to be a showing of cause as to, or public interest as to why that opt-out is appropriate. And I would suggest that there is no evidence. This is the first time we've heard of it, is today in this hearing. Second, I would also suggest that if those companies certain companies opt out and then successfully challenge the patents, what happens to the 50 cents that continues to get charged to the writing public here in Clark County? And again, this whole proceeding is so speculative. There is no litigation, only claims against Captain. I would suggest they were chosen because not only were they a soft target because of their finances, but a soft target because of their connections in the industry, their affiliations in the industry. There's been no actual signed agreement think this agreement is wholly deficient in many respects, so I don't know that it even would be the final agreement. No costs incurred. It was suggested earlier in this proceedings, I believe by the chair, that why would we not wait until there were actual costs incurred and have the applicants or have the operators come forward and show their costs and show that they were legitimately part of the rate base, and then consider whether a rate increase was appropriate based on those increased costs. And I would suggest that that is exactly what should happen in this particular case. When there are actual costs, when we're not speculating, then it would be appropriate to consider whether those costs should be passed on to the public or should be borne by the industry itself. With that, Mr. Chairman, I would be happy to answer any questions and simply say that I do not believe that under 706-151C that approving this pass-through charge would foster sound economic conditions in the industry.
Questions?
Nothing. Questions? Weekly damage.
Thank you, Mr. Chair.
Vice Chair.
Oh, opposite side of the questions that I asked earlier, and I need, what evidence do we have in the record to show that curve or NOPAB will not or is not in violation of those patents the same way as Captain is?
Well, first of all, I would suggest that your question assumes that Captain is in violation, and I would suggest that they are not.
I am making that assumption for purposes of the question,
Understood.
so I appreciate the qualification, but still, the question still stands.
Understood. And again, we believe that the patents are not novel and that they were obvious. We're going to digitize information we have. Yeah, that's pretty obvious in this day and age. It was pretty obvious in 2011 when the 852 patent was first filed. The only evidence we have, again, they didn't offer an expert, so we did not offer a rebuttal expert. But the evidence we have is we have evidence about the different technology that was in existence prior to the patents ever being filed in 2005 and 2008. Taxi meters have been around since 1976, according to Mr. Balaban's testimony. The other testimony we have is Mr. George stating that he talked to multiple companies, that he confirmed that they were aware of patent claims, and that he confirmed with them that they did not have a problem with those patents and that they were willing to indemnify his company against any claims of patent infringement. And in fact, AutoCap did indemnify his company against patent infringement. Third, we have testimony of Mr. Dewan. Mr. Dewan testified that he personally reviewed the patents and that he had patent counsel review the patents, and that they agreed that Curb's technology, again, he didn't speak to Captain's technology because it doesn't necessarily know what all is in it, but Curb's technology does not infringe the patents in their view. After he did, and he's got a very sound background, he did a review, he had patent counsel do a review. So we have testimony in the record. Is it as robust as it might have been if we had experts on both sides? No, but there's clearly testimony in the record that there are alternatives to the Captain technology, non-infringing alternatives to Captain technology.
So, and I probably should have asked this of other counsel too. And were you foreclosed from hiring experts in this case?
We were not foreclosed from hiring experts, no. But again, if they had hired an expert, my client might have been willing to spend the money to hire a rebuttal expert. Because it is their burden of proof, without an expert on their side, we saw no need to incur that cost.
So just I think I followed your rationale or your thinking as to their proposed argument that the 50 cents is reasonable, because you went into and you talked about the different industries and the different types of industries and that sort of thing. So where do you think the product that we're talking about here today that's going to be affected by this rate change, where does it lie in those strata of industries that you talked about?
I don't think it's in any of them in that website, to be honest with you. And so there is a general, if you go back and you read the website in the evidence, typically what you look at, if there is a rule of 25%, it's 25% of the net income of the licensed product. They're asking for more than 100% of the revenue from the licensed product in this 50-cent fee. Now, we're not saying that they couldn't sue the operators. We get it for using the licensed product or using it, but the measurement of the damages is still the same. The measurement of an appropriate royalty is still the same. It's not the taxi ride. You can do it. You can conduct a taxi cab ride without the technology. Again, less efficiently. We're not saying there aren't benefits to the technology. But the taxi ride is not the licensed product. For them to claim it is, and that that's the appropriate basis for imposing the royalty, is simply gross overreach.
That's all I have.
Oh, yeah. I don't.
Morning, everyone.
Thanks for being colorful today as opposed to your colleagues.
I just want to clear something real quick because it was brought up by applicants counsel about the timeliness of my posing brief, and I wanted to ask any questions on whether or not there's any issues relating to my filing brief that late.
What brief? No, I'm just kidding.
Unless another board member feels differently, no motion to strike brief file. It's been waived, in my view, unless somebody has a different view.
No problem.
All right, perfect. So I don't want to necessarily rehash the brief, but I was prepared for that in case no one read it, as the timeliness. From the administrator's perspective, it's always been about safety. His big purpose is safety. When it comes to the actual statute itself, and it has been discussed over and over again, there are 3 points. What is the rate? What is the justification? And is in the public's best interest? It's undisputed that the overall request is 50 cents. Whether or not that's reasonable, it's up to y'all. But I think that what is important was brought up is how this 50 cents is intended to be allocated. The first allocation is that, from my understanding, unless something has changed, is that 37.5 cents goes to IVSC and 12.5 cents goes to the technology provider. There's no argument or facts that I'm aware of that states that the 50 cents is considered a liberal fee that can be applied in any which way. And I bring that up because they bring in an opt-in contract, which I'll try to address later. And I also apologize if I'm jumping around. There's been a lot of note taking this morning. But I don't notice anything about that being a liberal fee. From my understanding, as the application sits, 37.5 cents is going to go to IVSC, regardless of how it is broken down. And 12.5 cents is going to go to the technology provider, however it's broken down. Next, we go to justification. I am not aware of actually any quantifiable evidence other than I believe the finance records from Desert Cab as to the actual number of costs and calculations that break down this 50-cent fee. My understanding is that the fee was discussed in a settlement discussion between Captain and IVSC. They, from what I read, from what I understand through the course of these proceedings, is that the fee is necessary to avoid litigation. And this 50 cents, from what has been argued, is less than the market value of what could potentially be the patent infringement claims that were brought forth. However, we don't have any lawsuits, we don't have any claims, we don't have any orders that actually break down what are the actual costs or where these costs derive from that would warrant 50 cents as being the best justifiable number for this rate increase. I also kind of want to point out, and at least at this point, is that Mr. Scheer brought up that there is that Captain does have a position in this fee. I mean, in the settlement, they were the ones that were given a demand letter. I'm not aware of any taxi cab operators receiving any demands. I'm not aware of any other technology provider receiving any demands. So I do think that there is a conflict in this settlement discussion when it comes to the 50 cents. Whether or not the intention is malicious or not, or selfish, I don't think that it was. I do think that when Mr. Bell said he did this in the best interest of his clients, I think that is a very genuine point of his testimony. But I don't think it can be avoided that they're the ones at the table because they were the ones that were brought there. From what I understand, no other technology provider, no other taxi cab operator sat at the table to have those discussions of what the realistic cost would be to them to afford this fee. Next is the best interest standard. From what I understand, again, this is how I understand things before going into this meeting this morning, because a lot of information has been brought up. This is going to be an industry-wide request. This is intended to be a 50-cent fee that applies to every ride that occurs within Clark County. Realistically, if we look at the numbers, only 2/3 of the industry are at issue because only Captain has been approached with this infringement accusation or allegation, which leaves, at least on the onset before walking in, about 1/3 of the industry who, from what I know, has not been threatened or been approached with a lawsuit. So a point of consideration is that this is at the structure, with the exception of the opt-in, opt-out contract, is going to be an industry-wide standard that probably more realistically applied to 2/3 of the riding public, or excuse me, 2/3 of operators. Overall, this seems like it's a bailout request, because if there's a threat of litigation, if there is a risk that is looming over the industry, the question I think that the board has in front of them is the threat of litigation enough to justify this increase? And I also think that the board should consider, do you want to set a precedent that a threat of litigation in the industry is enough to justify a rate increase? Because that's what we have here. Going back to my rightness argument that I brought up in my opening brief, if the rate is approved, the board is kind of making a de facto decision of whether or not infringement actually exists. And as we have now, we have two different arguments. Yes, infringement exists, or validity of the patents is in question. Or no, we don't think infringement exists, or no, we don't think that these patents are valid, or there's no issue with validity. But we don't know exactly what is or what isn't in existence. I agree with applicants' counsel when they said that belief is not evidence, but this is kind of what we're writing on. There is a belief that there is going to be such a hit to the industry that it's going to cripple it because of litigation. But I would also point out that even with this fee granted, nothing stops IVFC from exercising their rights on those patents. Because there's no agreement that says that, yes, if the board approves this fee, we are going to waive all of our rights under these patents. So what could also happen is that the board can approve this fee, and then when the parties have to go back to discuss these what I believe it's 4 agreements now. And I've been told when questioning the witnesses that these are draft agreements, they can go back and negotiate like, well, we have the board approve this fee, but you know what? In reality, we want 10 cents more, or we want this more. I have not heard any evidence that suggests that if the technology provider gets more money, right? If they get that 12.5 cents, is it going to prevent them from increasing their technology fees to their operators? Or are they going to somehow try to build in those costs? Right? Like they talk about that, oh, this is for this benefit and this is for this benefit, but I don't necessarily see anything in writing that states that that has been waived. I also think it's interesting that we do have, in this case, we have 2 operators on 2 opposing sides, and you have 2 technology companies on 2 opposing sides. And then you have a lot of operators that have been discussed, but none of them have been involved in this case, which then also begs this question. Number one, is it a concern for them here? Like, are they concerned about patent litigation? Are they concerned about being able to afford patent litigation? Can operators, are they stuck with the technology that's in front of them, or can they go out elsewhere? I think those are questions that we have, which is why, excuse me. I think those raise questions of like, what actual facts do we have? What actual hard evidence do we have beyond the testimony that was presented, which frankly, everyone has an interest in the testimony that they presented. And I take it to Captain's attorney's point, there's no way of knowing what is actual here because everything is speculation at this point. But again, at the same time, you as the board can determine whether or not that's enough to raise the rate. So from the administrator's perspective, what we've proposed, or there's 3 conclusions that you could take. As I outlined in my closing brief, there's questions of subject matter jurisdiction here because you deciding whether or not this rate is appropriate may also require you to make a de facto conclusion on whether or not there's actual infringement or validity. There's even questions about the indemnity, whether or not you have to make conclusions or decisions related to the contracts. None of that is within this court's jurisdiction, or this board's jurisdiction. So if need be, you can just dismiss based on subject matter jurisdiction. It doesn't prejudice the applicant because they can always come back and ask, or they can show like, no, this is what we have as actual costs, or this is the additional evidence that we can provide. If the board doesn't feel inclined to take that step, they can also just stay this until there's actual numbers presented in front of them. I agree that we don't know. We just don't know. There's still a lot of questions after 10 months of depositions and asking for documents and 3 days of hearing. Even now with the opt-in or opt-out, from the administrator's perspective, there's no way that they can regulate that. How do you know which operators are opting into a fee, which operators are opting out of the fee, especially if part of the terms of that agreement is that it be kept confidential? Another point that I did not hear, and maybe the other council can touch on it, is whether or not this 50-cent fee, this collection, is going to stop for the people that opt out. Because from my understanding, this 50-cent fee is still a collection that happens across the county. There's also talk about holding it for credit. I don't remember seeing that in the papers. Whatever that looks like, we just don't know. I also kind of want to point out, as just a caution, is that if the board were to decide for this rate, and this is actually my concern from the from my personal position of whether or not when I represent the administrator, when I review contracts for them on their behalf, is does this create some sort of de facto purchasing contract under NRS 333? Because the way that the fee breaks down is that 37.5 cents goes to a single entity who is being questioned of whether or not they are entitled to that 37.5 cents. If that is the case, where the writing public, as the public, pays money that diverts the publishing requirements under NRS 33, or excuse me, NRS 333, there may be a different issue that the board may have to face other than just this rate increase. At that point, at this time, I reserve my right. If you have any questions, I'm more than welcome to answer them.
No question.
Any questions down there?
Yeah, I have one. You were referencing the 37.5% that will come out of that 50,
37.5, yeah.
37.5, and the other was 12.
12.5 cents.
So those that opt in, will they each get that 12.75 or that, what is it, 12.75?
So,
Or
I'm not-
12.5, or are they divvying up 12.5?
so can I, before you answer that, can I just simply say that the opt-in, opt-out, it's just a proposal that was made today. There is no evidence on this
Yeah.
and what they're intending to do. So I don't think we should be trying to build
No?
evidence on something that's not in the record.
Yeah, okay, because
I don't
I
mean
know
to
it
cut
was-
you off, but
Mr. Chair,
I mean, she can answer it. I'm troubled with trying to take evidence on something that was thrown out today for the first time.
so at least to the extent of the evidence that we have in the record, my understanding that the 50 cents when it was initially proposed was to essentially pay infringement costs. That's why I refer to it as a bailout, because it seems like it's being presented that the industry is in a position where they need to be bailed out, and they're asking the board to basically have the writing public bail them out. I want to say maybe during the first round of depositions, I know it was brought up in the responses to the request that the administrator had. They broke down that 37.5 cents would go to the patent holder, which in this case is IVSC, and then the 12.5 cents is supposed to go to a technology provider. Then it raises other question of if an operator has multiple forms of technology, how do you break that down? Because a lot of operators, including taxi management, they use more than one technology provider for different things. So who's actually entitled to that 12.5 cents? Or how are they supposed to split that up? That's my understanding of the fee breakdown.
Thank you, Mr. Chair. Technology providers.
That is in admissions. I have a couple. Oh, go
I have
ahead.
a couple. So your second proposal is a stay until actual numbers are known.
Mhm.
What actual numbers are you talking about?
There's threat of a lawsuit anyway, right? And I just also want to point out for the record, people get threatened with lawsuits all the time. Lawsuits happen, whether they're valid or not. But as far as I understand, there's a threat of a lawsuit looming over the industry. We don't know the outcome of that. So if there is actual serious desire to pursue that route or pursue that route against folks that don't enter into a license, then stay it. And then if the industry is in a position where they need to be bailed out, then we can revisit that.
So what you're saying is pay and chase. So as opposed to, it's like indemnity. Indemnity doesn't come to fruition until $1 has been paid. Is it your position that $1 hasn't been paid? So we're not in a position to say that they need to be bailed out.
I don't know if $1 has been paid. And I think that's kind of the issue with the justification behind it is I don't know what has been paid, what has not been paid. believe that there was testimony about how much money has been paid into preparing this application and for a review, I believe by Captain. I believe that Andrew Myers did testify as to how much Captain has paid, but I don't know of anything beyond what is the actual infringement damages in this case. What is the actual indemnification damages in this case as well?
So is your proposal to be stayed until there's an adjudication by a patent court or something that specific, or what are you talking about? Or you're willing to say everybody experts up and they come in and provide testimony as to this is what we think it's going to cost, this is what they think it's going to cost? I mean, what is your proposal?
So I think it could be stayed after review by a court of a competent jurisdiction. Because there is talk of different types of courts, whether it be through the USPTO, whether it be through federal district court. Another allegation that has been brought up through the course of these proceedings is the indemnification rights of the operators against the technology providers. If there's any desire for them to pursue that or to assert that defense, that could probably impact the actual cost of damages that would be paid out to the patent holder, assuming that the patent holder has a valid claim. I think it's an option if the board is on the fence. I personally would go with the first one and just dismiss due to lack of subject matter jurisdiction, because you're not a patent board. You can't determine whether or not patent infringement does exist or patent validity does exist. But by granting this fee, you're kind of making a decision that, yes, patent infringement does exist or patent validity does exist, because here's this 50 cents as the way it is written is going to be allocated. And then through 7.5 cents is then going to go to the alleged patent holder.
Go ahead.
On that latter point, you're claiming that we have the ability to find that there is no subject matter jurisdiction. But are you contesting, is the administrator contesting that we have jurisdiction to entertain a rate change?
There's no contention that you have.
Just answer directly my questions. Is there a contention, yes or no, that we don't have subject matter jurisdiction to decide whether to grant a rate application?
No,
Yes, sir.
if I understand your question correctly, no, there's no contention of your power to determine a rate.
If, so this is a hypothetical, there is a way to resolve this case without concluding that there is a valid patent or there is infringement under applicable law in processing a rate case. Yes or no, is it your position we couldn't then have subject matter jurisdiction? Assume for the moment, you don't have to decide validity or infringement, but there is a path forward legally under the law that does apply to us and that we do have authority over, that we can't proceed.
So the answer is yes, you can proceed. Would you like an explanation?
Do you have a position different than what I understand to be the law, even before it was said today, that there is a federal statutory presumption that the patents issued are valid? It's a rebuttable presumption, but it is a presumption absent other evidence that the patents are valid. Do you have knowledge of some law that is contrary to
Maybe. And I'm sorry, it's not the answer you're looking for, but there is a case that I found that it's Technology Licensing Corp. Versus Videotech Inc. Case number, if you would like it, is 545 F.3D
455 Fed Second.
545. It's Federal Circuit, so F3D
Federal Third.
Federal Third 131, or excuse me, 1316. I believe it was pin cited to 1327.
Mhm.
Fed Circuit 2008. It did a review under 35 USC 271, where it just talks about the responsibility of basically enforcing your presumption of your validity.
Mm.
It's up to the plaintiff to bring forth their matter and to support their matter.
Well, that's the rebuttable nature of the presumption,
Correct.
Okay.
So I don't know if that is
just like a Chapter 47 presumption under our evidence code. They're
Correct.
rebuttable.
And I state that because I don't necessarily know if I understand how you understand it, but my understanding is like, yes, there is a presumption of validity. There's not a presumption as to infringement. So in order for someone to protect their patent and to show that it is valid and worth enforcing, it is up to them to bring it forth.
So your subject matter jurisdiction argument is not categorical.
No, but I think it's something that the board should consider, because if the board's decision is that it is in the best interest to protect the industry from infringement costs, they're making that decision as a de facto decision that there is infringement in existence or validity.
So what I'm struggling with, Ms. Guerra, is subject matter jurisdiction, which means we have no power, versus failure to state a claim upon which relief may be granted. There is a very deep chasm between those two, and I'm trying to understand if you really mean subject matter jurisdiction or you mean that there is failure to state a claim.
Understood, Mr. Chair. And maybe this will provide a little bit more light to that. I'm currently working at a case for the MRB in front of the Supreme Court, where that board didn't make a decision on something that was within their subject matter jurisdiction because it relied on facts outside of their subject matter jurisdiction. In that particular case, there was issues with a Title 82 matter that would have been a determining factor within their NRS 288 matter. So because this matter wasn't resolved, they didn't feel that they had the abilities to resolve this one. And that might be an issue, at least from my perspective, that we see here. Because if the patents are in fact being infringed, then it's understood why they may seek the board to assist with paying for the damages that were caused from the use of the patents. But if the patents are not valid, then the board doesn't need to issue that bailout. So I guess the position that we have here is that if you do allow the rate increase based on the fact that an infringement did in fact, if based on infringement, then you're basically saying infringement did in fact exist, or the patents are in fact valid. But there's clearly a dispute between whether or not infringement has existed or whether there's not validity.
Raise the State Procurement Act 3333. And so I'm not at a disadvantage here. I regularly litigate in that matter. It matters. On what theory are you using that there is a act by the state of Nevada to make a procurement of goods and services for the use of the state of Nevada? I do not understand that argument. I want to just make sure that I'm not missing something here. Because that's the predicate of that statute.
Understood. The concern under 33B.
3333.
Excuse me, 333. Yeah, State Procurement Act, Purchasing Division chapter, is that when you take funds from the public, when the state takes funds from the public, however it may be received, or if the state receives it, then there has to be certain provisions and requirements that those that receive those funds have to meet, right?
How is the state receiving these funds? These funds are being received by either the patent holder or by the technology provider. That analogize your argument, just so we don't spend too much time on it. To
Understood.
the Public Utilities Commission says NV Energy, you can charge 32 cents per kilowatt hour. How is the state involved in that transaction other than approving that that was a just and reasonable rate under that law?
Outside of that, there's not. And I'll be upfront with that, it's not.
Okay.
But there is a concern that this is an attempt to bypass the requirements with the public funneling funds to one entity.
Well,
Bless you.
when a rate is granted to NV Energy, they're definitely funneling money to a single entity that's providing electricity in the state. So okay, I get your argument. I get those to the final thing. You acknowledge that one of the elements that we have to determine is whether the rate is just and reasonable, correct?
Correct.
What does just mean in just and reasonable, and what does reasonable mean? Those are terms of art. Do you know what they mean?
There's
And
no,
if you don't, that's fine.
there's no specific definition of reasonableness justification. There are arguments of whether or not it is justifiable or reasonable.
Council? Do you not know what the term just and the term reasonable mean under public utility, public rate making, going back to 1890s? I'm just asking. If you don't know, just tell me you don't know.
Not for the PUCN.
Okay, thank you. I don't have it. And I'm not trying to be hard on you. I just,
No. I welcome it.
I will say to Ms. Guerra's point regarding purchasing, it's not completely outrageous for an agency that's not the PUCN to approve a cost to be charged by a licensee to go to a specific entity and for purchasing to come through and say, we'd like a contract for service.
like smog detection devices,
Right,
my client.
right. There you go.
Any other questions? Thank you very much.
Thank you.
Ms. Pincer, you may have the opportunity to rebut. If you could be brief, brilliant, and gone, that would be great.
I will be as brief as possible and just to kind of touch on 2 or 3 overarching issues. I think after all of the closing arguments, you know that this matter, if it goes to court, isn't going to be won on summary judgment. You're going to have contentious litigation. Everyone's lawyering up, and the numbers that Ms. Guerra suggests be brought back are essentially engagement letters, patent attorneys being hired at presumably 3 times my billable hour, and you're going to have a big giant question mark on what is IVSC going to do and who are they going to do it to. So I think the applicant and all the supporting interveners have proposed a solution. The opposition interveners and on behalf of the administrator just propose, let's litigate and come back. And that underscores and undermines the reason why Desert Cab brought this in the first place. You also have this skepticism and criticism regarding unexecuted agreements. These agreements have not been signed. There's so many question marks about them. But then on the other hand, you have all these aspersions having been cast against Mr. Bell, Mr. Myers, and even my client. This was some backdoor deal that we're trying to bind the entire industry. The reason they were left open was to be transparent, was to bring these agreements to you so you can consider them, so that there can be some input and ultimately conditioned upon you approving the final agreement. Had we locked this in further before these proceedings even commenced, that would be even more suspicious. Oh, well, they did this and inked this on behalf of the industry without even coming to us. And the facts that are on the record was that Captain conducted an industry-wide meeting. And this happened the latter of 2024. So they put this on the radar. Everyone knew this. This wasn't skulking behind alleys, trying to get some deal done, inked behind people's backs. So I think the lack of execution of these agreements shows integrity and shows respect for the input of the contemporaries. And again, we don't want litigation. The only solution here is let's litigate. And with the opt-in, opt-out, I know that's not part of it. If that does become part of the solution down the road, I think the record does support that, because all of the opposition arguments regarding it's not in the public interest would support their reasons for opting out. And then they can face IBSC and the wrath of IBSC should they choose. But after everything that you've heard today, the application does satisfy all the statutory and regulatory requirements. It is properly before the authority, and for the reasons set forth in the record, Desert Cab respectfully request that you approve the application. Thank you.
So if the board members are in agreement, I'm gonna suggest we take a recess till 25 before the hour. We need more than that before we bring it back. Okay, so let's take a brief recess till 25.